We have breaking news from Peoria, Illinois, where a verdict has been reached in the trial of a former Illinois sheriff deputy charged with first-degree murder of 36-year-old Sonya Massey. Sean Grayson was convicted of second-degree murder in connection with the July 2024 incident. Sentencing will be January 29th. Now, Grayson testified in his own defense, which can be rare in a murder case. He said he feared for his life and shot Massey in self-defense.
Hey, this is Fugitive TV. I kept getting hit up asking me to break down why Sean Grayson, the person who just got convicted of unaliving Sonya Massey, and Sean Grayson was the police officer, of why he got convicted of second degree unaliving but not first degree. So people were asking me to break this down. So I'm going to give you a quick video of why he got convicted of the second degree but not the first degree. And I'm going to give you in terms that you can understand. All right? Fugitive TV. Welcome back. This is Fugitive TV, and I want to give a big shout out to everybody who's been liking, subscribing, sending me all kind of information on cases that I have been doing. And me as a journalist, I take this seriously, so I keep all information private. I keep you anonymous unless you want me to say your name. And not only that, I've been reaching out for people, or people been contacting me, I should say, to been do interviews, all kind of things. So I appreciate all that. All right. Now, today, what we're talking about at this moment is Sonya Massey. Now, for you guys that don't know, just a quick recap, Sonya Massey is the person that was unalived by a police officer. She called 911 fearing that somebody either broke into her house or was inside her house. Officer Sean Grayson showed up, him and his partner, at the house. While they were there, I should say, there was a confrontation between Sean and Miss Massey, and it ended up with Sean unaliving Miss Massey. Okay, now the way it happened, there is video of it, but I'm not going to put it out here on YouTube and things like that. But there is video of it. If you can look at it and you'll see it. There's a video of Sean, I should say, Miss Massey. She's in the kitchen, right? And at that time, they kind of have like this little heated exchange where Miss Massey grabs a boiling hot water in a pot and pretty much, in a way, threatens to throw it on Sean Grayson. She's like, in the name of the Lord or name of Jesus, I rebuke you. And then, Sean Grayson has his weapon out pointed at Massey. And then he warns her and says, hey, put it down or I'm going to KILL you. I'm going to KILL you. I think he even says he's going to bing her in the head at one point. Well, anyways, he ends up, um, using his weapon against her and unalives her. Well, he went to jail. He's been in jail this whole time. His trial just happened. Well, some people are upset over the outcome. So the jury convicted him of second degree.
Tell us what you're learning here about this case and this verdict.
Well, we were looking at 3 counts of first degree. And it was only a day ago that we learned that actually 2 days ago, right before jury deliberation began, that the jury could actually consider second degree if mitigating factors led them to believe, yes, he did, but he had a reasonable defense in that he feared for his life. So that was actually new and came late in the game. We learned right before jury deliberation that was possible. And we just in that is in fact what the jury came down with.
Which was the lower charge of the first degree. They didn't convict him of first degree. They convicted him of second degree. And I'm going to tell you exactly why. How his defense was able to sway the jury from first degree to second degree. Now, I did time. And while I was in there, I spent a lot of time in the library, the law library, where a lot of other people spent time gambling on tables, playing spades and dominoes, okay? I spent a lot of time in a law library and reading other cases, sometimes even reading about charges that I had nothing to that weren't even, to me. It was just to pass time. But over that time, as I was doing this, I was able to even start helping out other inmates who were facing other charges. And a lot of them, let's say they would have a public defender. Not to put a bad rap on every public defender, but public defenders usually have a lot of caseloads. They got to go through hundreds of caseloads in a day, in a week, whatever it is. So a lot of times they got a big file on their desk and they got to go through all these caseloads. A private attorney knows how much he can handle. So a lot of times a private attorney, let's say if they're going through a trial right now, they might not take on a new case because they need all their time to fight for this one individual on trial. A public defender, it usually doesn't happen that way. So even the public defenders in trial, they're still getting more cases. All right. So because of that, a lot of times they don't have the time to go and do deep dive research on everybody's case and to fight for them 100%. As a private attorney can have more power over their time and choose exactly what they want to do. All right. So that is one of the differences between when you have a public defender and when you hire a private attorney. I'm not saying all private attorneys are going to do this for you. I'm not saying that. But this is how it's supposed to happen. All right. I've had a public defender in my earlier years, and it was the worst experience. And then when I turned myself in, I ended up getting a private attorney, and it was the best thing I ever did. All right. So, like I was saying, this is not to bash any attorney that's out there. I was just pretty much giving you of a fact basis of what a lot of inmates go through or people facing charges. Now, because I was going to a law library, like I said, I was able to help out under other individuals. Okay. Um, they would ask me a question and be like, "Hey, we know you're in a law library all the time. Would you look up my case and see what you can do?" So that's what I would do. So I know a little bit about first degree and second degree because of this. All right. Now, every state is a little different. So I did go and look at the state of Illinois, the difference between first and second degree, which I'm going to bring up to you guys. All right. So this right here is the statute from the state of Illinois on first degree unaliving. So we're going to read exactly what it says, okay? It goes, a person who unalives an individual without lawful justification commits the first degree unaliving if in performing the act which caused the unaliving, okay? Basically meaning you went out and you did something and you can't justify what you did whatsoever. There's no excuses on it, all right? Then they have a section under A, which is 1. He or she either intends to unalive or do great bodily harm to that individual or another, or knows that such acts will cause passing to that individual or another. Meaning this is your intent. Your intent is to try and do this to them. And you really don't care, all right? All right, then you have 2 under that. He or she knows that such acts create a strong probability of unaliving or great bodily harm to that individual or another. Meaning you already know that if you do this or use your weapon, this person is probably not going to survive. Okay? Then 3, he or she acting alone or with one or more participants commits or attempts to commit a forcible felony other than second degree unaliving in the course of or furthermore such crime or flight therefore. So that basically is saying if you and your friends gathered around and you're talking about this, what you're going to do to a person, you're in first degree. You're in first degree. There's no questions about it because you're even having conversations about it. Okay. There is no fight or flight at that moment for you because you already are assuming this is what you're going to do. Now, let's take a look at the second. Now, this is second degree, all right? The first one was first degree. This is second degree. So, under that statute, it says A person commits the offense or second degree unaliving when he or she commits the offense of first degree, all right? As defined in paragraph 1, which we just read paragraph 1, or 2 of subsection A. We just read that. Now, this is a lot of court jingle, a lot of courtroom talk, law talk. And I know this is why people don't understand sometimes certain laws because they don't really, even though the words look simple, it's how they word it to make it to where people don't understand. Now, Section 1. At the time of the unaliving, he or she is acting under a sudden and intense key word, okay? You got to look at these key words. Passion, resulting from serious provocation by the individual who is unalived or another whom the offender endeavors to unalive. So, when you look at this, there's certain words you have to look for. A sudden and intense passion. So, when she had up that pot of boiling water, and then he said, "Put it down, or I'm going to do this." It was a sudden, intense passion. All right. But he or she accidentally caused the unaliving an individual who was unalived, or two, at the time of the unaliving, he or she believes the circumstances to be such that if they existed would justify or exonerate the unaliving under the principle stated in Article 7 of this code. But his or her, here's another key word, belief is unreasonable. So, was his belief that he was in danger or not in danger? Belief is his, not yours or mine's or even his partner, but his belief. Serious provocation is a conduct sufficient to execute an intense passion in a reasonable person provided. However, that inaction does not otherwise constitute serious provocation. Cannot qualify as a serious provocation because of discovery, knowledge of disclosure or victims. And it says sexual orientation as the defined in section, and it gives you the statute, okay? Now, like I said, when you read this, it looks like a bunch of simple words, but it's how they put the words together, how they rearrange the words to make it to where an average person is not going to understand what they're reading. So because you won't understand what you're reading doesn't mean you're going to understand the law. All right. The last part of it says, I don't know if I'll read the whole thing. When evidence of either of the mitigating factors defined in subsection A of this section has been presented, the burden of proof, keyword proof, okay, is on the defendant to prove either mitigation factor by a preponderance of the evidence before the defendant can be found guilty of second-degree unaliving. The burden of proof, however, remains on the state to prove beyond a reasonable doubt each of the elements of the first degree when appropriately raised, the absence of circumstance at the time of the unaliving that would justify or exonerate the unaliving under the principal statute. And then it goes on to tell you what the statute codes are. So we're going to break this down in fifth grade terms so we all can understand it. It's basically saying the burden of proof, okay? Meaning that the DA needs to show burden of proof that it was premeditated. They need to show burden of proof to the jury to convince them that it was premeditated, okay? Second degree unaliving is pretty much automatic is what this is saying. It's pretty much saying if you unalive some person second degree, it's pretty much going to be automatic. Now it's up to the DA, though, to escalate that to a first degree and find you guilty of that with burden of proof. The DA in this situation did not have burden of proof enough to convince a jury of the first degree. The DA, all they had to defend was, hey, this is second degree and this is what it's going to stay with, okay? That is exactly why this happened.
That what we're looking at is one of two mitigating factors that essentially would undercut the idea of premeditation that we talk about for first degree. So when it comes to second degree, what can bring you down? One is acting in a intense passion as a result of actions by the victim. Another is acting in self-defense where it's not reasonable, but you subjectively believed that you were acting in self-defense. And given what we've heard over the trial, I think that's where we see the jury ultimately land here, is that they do think that there should be punishment. They do think that it is. He did feel that there was that mitigating circumstance, again, based on the other evidence that the defense presented.
Now that you see the difference between first and second degree, I'm going to tell you how the defense was able to beat the first degree and get the jury to agree on the second degree. Now, first degree is premeditated, okay? First degree means in your head, you already thought and planned this out that you're going to do this to this person. First degree can go as deep as you woke up early in the morning, or you woke up that day, and as you was getting dressed, you packed your weapon on you and you're like, today I'm going to go off somebody. That is the start of premeditation. Today I'm going to go off somebody, and this is what I'm going to go do, especially if you have a certain victim in mind. Now, if you have a certain victim in mind, then it's definitely first degree. All right. Now, second degree is supposed to be no, you're not thinking about it ahead, as in there's no premeditation. You're not waking up, you're not thinking about you're gonna go do this to this person or whatever it is. So basically they're saying Sean, when he arrived to work that day, he was not saying that this is what he's gonna do. So that's one, okay? The second thing is when Sean knocked at that door, they could not prove, or I should say the district attorney could not prove that when Sean arrived at the scene that he already had thoughts or premeditation that he's going to do this to her, right? So like, let's say if he would have knocked on the door, he already had his weapon in hand and he's already pointing at her when she opens the door. Now you could say it's okay, maybe he might was thinking of this at first, but he wasn't. So he walked into her house and everything without the weapon in his hand, right? And pointing it at her. He didn't point it at her until she had that pot of boiling water. Now, second degree is when a person or individual unalive somebody and their belief, okay, key words, their belief, not you, not me, not so-and-so down the street, but their belief that their life could be in danger. Okay, so when Miss Massey pulled up that pot of hot water and said what she said, that's when he gave her that warning, put it down. Now, if he didn't give her that warning and just straight fired at her, it might be a different story. But he gave her that warning and said, put it down. And when he gave her that warning to his belief, remember, once again, his own belief, not you and not anybody else, but his belief, he felt that his life was in danger. And then, of course, we all know what happened next. He unalived her. All right. His defense did a great job of getting the jury to believe that he felt at that time, in the heat of the moment and passion, that he himself was being threatened, was going to get harmed, maybe even his life taken away. All right. So the defense did a good job of saying, hey, this was not premeditated. Yeah, he might have said, put it down. Okay. But I'm going to do this. But the only reason why he said that is because she had a hot pot of boiling water. All right. So one thing that lawyers do, or I should say they're supposed to do, is supposed to study cases, past history cases that could be relevant to like what's going on with your case, right? So let's say if a person beat a certain charge or a charge that you're, facing, sometimes they'll go back and look to see how they beat it. And then even the district attorney, sometimes they'll go back and they'll look at a case to see how they were able to prove or how they were able to get them convicted of a certain charge. So this case right here is a past case. All right. This is February 14th, 2013. Now, when I did my time and I spent my time in a law library, a lot of it is looking at old cases. That's what a lot of it is, to figure out what the ruling is, how they beat it, or how they got convicted. So this person, it was the people, state of Illinois. So you have the same state versus Asher Hadou. Now, I'm not going to read this whole thing for you. I already read it. It's pretty long. But Asher Hadou was convicted of first degree, not second degree. The reason why he was convicted of first degree, I'll give you a quick rundown. He was actually, it was pretty much like a love triangle. This girl was dating this new guy named Kiki, and Asher was pretty much like the old guy. Asher was kind of jealous of Kiki and just, and you know, mad. You get the idea, right? So anyway, Asher was also gang related. Now, a lot of people were scared of Asher because he would make threats towards people. Now when you're making threats towards someone before you do it, that could be considered premeditation. Okay? As in, it's not a self-defense threat, but a threat for no reason. So let's say you approach me and you have a weapon in your hand, or you have something in your hand, and then in return I say, you know, if you make one more step, I'm going to do this. That could be a self-defense reaction. Now, if you're just walking down the street and then I approach you and I go, I'm going to do this, and you have nothing to do with it, now that could be first degree. All right. So that is the difference. Now, what happened was Asher used his weapon, which was a knife, and poked Kiki a lot of times. Okay. Kiki ended up passing away, and that was how Asher got first degree. But it was a lot of what happened before the first degree, of how he used to put threats out. Not only that, walking around with this big 6 to 7 inch knife for no reason too. Um, People knew that he was threatening Asher as well. And not only did he poke him one time, it was numerous times. So he didn't just poke him once, you know, but it was a lot of times. Almost like, I'm going to do this. I'm going to make sure you're not going to be alive tomorrow. All right. So that was how this case went down. Now, I mean, you're going to, you question yourself, it's only a hot pot of boiling water. You can't, pass away from that. And you might be thinking about this, right? And you might be thinking of, why didn't he pull out his taser and taser, right? Me, same thing. Why didn't he pull out his taser and taser? But in return, the defense came back with, he felt that the taser wouldn't work because of what she was wearing. I don't know if you guys ever been tased before with the police taser, all right? But those tasers, what they do is they shoot out these prongs, and the prongs stick into your skin. And when they stick into your skin, there's a trigger, and they can keep pulling it, and they can keep shocking you. Now, if those tasers don't stick into your skin, if they just hit the clothes, it's ineffective. It's not going to do anything. And then at that moment, she could have thrown the hot water on him, right? So he said that he felt the taser wouldn't have done good because of the clothing she was wearing. It wouldn't have stuck into her skin. I don't know if that's true or not. I'm not going to sit here and say, hey, he's right or he's wrong. I don't know. I wasn't there. I've been tased myself while I was locked up. People start fighting, they start tasing you. So I know what it feels like. Did I have clothes on when I got? Yes, I had the jumpsuit on. But then again, the police in there, that's all they have is tasers. They don't have a choice. They can't say taser. They can't say this, right? They can only tase you. So I don't know. I can only tell you of some of these facts of why the defense won when it came to second degree, because he's still going to do time. He's still doing time. I think the judge's still going to give him time, but it's not going to be as long. First degree is a life sentence, and I believe second degree in the state of Illinois is up to 20 years. I don't think there's a minimum for second degree, though. That I have to look into, but I don't think there's a minimum for second degree. But the judge can give him up to 20 years, and I believe he is going to get some time. Now, When I was in that place locked up, right? There was a guy that I was in there with, and this guy defended himself. Believe it or not, he defended himself. He was facing a first-degree charge, okay? Quick story. You know how you have those family fun centers or whatever, where kids or, they have arcades, batting cages, go-karts. They don't have them a lot anymore. They're taking them down. But this is where this crime happened at. He was in one of those places, and I believe it was with his family. That's why he was there. And I don't remember the whole like little details, but another guy was there, and some sort of way, something happened, and the guy that I was locked up with ended up pretty much taking out a sword and chopping this guy up right there in front of family, kids at the Family Fun Center. Guy passed away. He's facing first degree unaliving. This guy defended himself. No lawyer. Won and got manslaughter. He got manslaughter, which is a big difference from unaliving. So he went from life to facing, I think it was up to like 10 years or 12 years, and where we were located at, all right? And by himself. I don't remember all the details of how he was able to do it, but I do know this man spent every waking minute, hour reading the law of how to beat his own charge. He did not trust his life in the hands of another person. He trusted it in himself, and he also took the stand, the same thing Sean Grayson did. He took the stand so he can convince the jury of what happened. But he was able to get from first degree to manslaughter, and he chopped this guy up with a sword. Like I said, I can't give you all the details. I don't remember because it was so long ago, all right? But I bring that up to let you guys know, whenever you're on trial and you're facing one of these charges or whatever, even if you have a lawyer, try your hardest to even look up your own charges. Try your hardest to figure out how you can even beat them. And the same thing goes with the DA. The DA, needs to be looking at the charges and figure out how they're going to beat the defense. I've been talking about Kata Scott a lot lately, and talking about Keon's lawyer, Shaka, right? Shaka has a job to do. Shaka is supposed to be defending Keon and trying to get Keon either as less time as he can or completely off. The DA has a job. They have to try and convict Keon on the evidence that they do have, and not let Keon off, and try and get as much time as they can. So both people have jobs to do, but it all depends on who does the job better, and when you go to trial, which job convinces that jury. All right? If you have anything you want me to cover, if you've been watching my videos before and you want to do an interview because you might know something, I mean, even if I've been, talking about you, for instance, with the Gabby or Kata Scott, Keon King, Gabby D, hey, any of you guys, you're welcome to come on here. You're welcome to speak your truth, and welcome to speak what you want to speak, all right? For you guys that's been rocking with me, I appreciate it. For all you new viewers, please turn on the like, subscribe. You know the rest. My information is at the bottom. This is Fugitive TV. We out.